Well, first and foremost, it's an absolute pleasure to be here virtually today. I mean, it's been a fantastic, fascinating conference of a number of erudite, really fascinating papers. Well, that's all going to come to an end now. No, I mean, in all seriousness, what we've seen today really has been inspiring in terms of seeing how innovative and how central legal history can be to the law curriculum. But what we've been talking about today through various different presentations is exceptional. And as lawyers, we know that exceptions prove the rule. And the rule still is that legal history is not central to legal education in this country and indeed in other jurisdictions, as we've been hearing. And so, although there's an element this afternoon that I'm preaching to the converted, indeed I'm preaching to the choir in many ways, or I'm preaching to senior figures in the church who are doing a damn fine better job than me. What I want to try and do in trying to bring together some of the ideas which previous papers have developed in a far more erudite way is the reasons why legal history is important and should be at the beating heart of what law schools do. And, you know, although I'm preaching to the converted, what I'm hoping to do is to develop arguments that we can collectively use on the unbaptized, if I can push my analogy to breaking point. But let's begin in 1901. And let's begin with the patron saint of legal history, Frederick William Maitland. And in 1901, Maitland was pondering why the common law had survived the Renaissance. He asked in his Reed lecture, how was it and why was it that in an age when all old creeds of many kinds were crumbling and all knowledge was being transfigured, in an age which had revoluted against its predecessor and was fully conscious of the revolt, but one body of doctrine, the common law, remained so intact? And the answer which Frederick Maitland came up with was that it was the Inns of Court which were the main reason why the common law had been preserved. And as he put it, law schools make tough law. By teaching the law, we are conserving it. And by teaching the law, we are also limiting ambitions by showing this is the way things have always been done. And by implication, this is the way things should be done in the future. So, developing this argument that law schools make tough law, or law schools to an extent narrow opportunities, narrow perspectives, it's worth noting, as many commentators have done, that law students have a very different experience compared to other students. They're using unique sources and materials and attributing them with authority in a way which is very different from other humanities and social sciences degrees. No one questions the authority of an Act of Parliament. No one questions the authority of a bias of a judgment. And materials are consulted more like a detective than a scholar, because we're teaching them, and we've heard this phrase at numerous points today, to think like a lawyer. Or actually, let's face it, to think like a High Court judge in terms of the traditional expectations of what a law student would be doing. So some people say that lawyers and law schools don't teach method, but that's absolute poppycock, because they do teach method. It's in those foundational to law courses we heard about earlier. And indeed, throughout the law degree, law students are inducted into the legal method. And they learn not only how to use, but how to respect the authority and how to operate within the world of law. And their task in most law assessments is to systematically present and apply the law. They critique it, but crucially only within the law's own terms. Other questions, questions of context, questions one might say of conscience, actually, are seen as non-legal questions and inappropriate to bring in on an essay question on how the word recklessness has been defined by English criminal law, or a problem question on resulting trusts. So the first problem I think we have is the narrowness of legal education. And Anthony Bradney, in a fantastic article in the Journal of Legal Studies in 1998, summed this up provocatively, but meaningfully, where he said to become a law student, the student must forget who he or she is. Thinking like a lawyer means very often that you stop thinking as yourself, and indeed you stop questioning in the ways that you would naturally do so. Let's take another date, 1888, and we're still with Frederick Maitland, and he's opining again, and he's given his inaugural lecture in Cambridge, a long and dismal discourse, he called it, and that's something I seek to emulate really in this presentation. But his key point in his inaugural lecture was that English legal history was not flourishing quite as it ought to flourish. The truthful English historian will have to confess that he had but flitted over the surface. There is, I think, some danger lest the history of English law should be better known and better taught in other countries than England. And over a century after that inaugural lecture, a lot of what Maitland was saying there, a lot of the spirit of what Maitland was saying there remains so. It remains true that the history of law is taught more in jurisdictions other than England, and indeed an argument can be made that the history of English law is much more widely taught in America than it is in English universities. And paradoxically, in English and indeed Welsh law schools, and I'm not going to mention Scotland here because we've heard some presentations earlier about the numerous legal history courses that exist in Scotland, and we might sort of question why that difference is. Is it part of the civil law tradition? Is it part of a longer degree tradition? But it does seem to be different to the experience in England and Wales. So in England and Wales, in English and Welsh law schools, history is seemingly everywhere, because every romp through the cases, every discussion of precedent, every elucidation of a case law seems to be historical. And students will come across cases and come across statutes which are not modern, or in terms of at least being not 21st century. But also, at the same time, it's nowhere, because, and there's no need for the duplication of legal on that slide, but history is paradoxically also nowhere, because when you're going through the history of the term intention in criminal law, or through the case law on a particular topic in land or contract or tort or whatever, that's not really history. You're just using those cases to understand the present law. And it's rarely the case that law students, law textbooks, law lectures actually look at those cases in their historical context. And when I'm talking about this, I often put forward what I like to call my novel analogy. And my novel analogy is that for most of the time, the experiences of law students is like studying a particular chapter which they think is somewhere towards the end of a novel. So a course on land law, a course on trusts, a course on tort feels to them like a very detailed study of a particular chapter which they think is somewhere towards the end of this novel. In studying just that chapter, they've got no idea, or very little idea, of what has happened before. what plot lines there's been, the ebbs and flows of those plot lines, ways in which things were advanced, ways in which things were regressed. And as a result, they've got no idea really of where things might go in the future. And so that's our second problem, the fact that legal history is not central to what law schools do. And this quote from a 2012 article says that legal history is in a coma. And I'm not sure I'd quite agree with that. I think the evidence we've seen today, and these papers are really just the tip of the iceberg in terms of the rich historical research which is happening in law schools, let alone the rich legal research which is happening in history departments, shows there's quite a lot of legal history stuff out there, but it's not central to what law schools do. And so I think these two problems, the problems of the narrowness of legal education and the problem of legal history not being central, are linked. And the more I thought about this and the way in which they were linked, I developed this idea of subversive legal history. And like all ideas, it builds upon ideas that were out there and which were pre-existing. There's not that much, if anything, which is particularly novel or original about it. But it's a way of bringing this together and making an argument. Because the book on subversive legal history, if people, see it as being novel and as being a good read, great, but its main purpose is as a manifesto, as a revolutionary text, as something which can be used in order to develop legal history as something which is the saviour of legal education. So it's all developed in that book, which the good news is that it's out in paperback after Christmas. The bad news is you can't buy it as a Christmas present, but nevertheless, you can, from the 19th of December, you can pre-order a version which will not cripple you financially. And everything I'm about to say develops and summarises what is in that book. So there are two principles of subversive legal history. And the first principle is to try and unite all the great stuff that's going on in terms of research, in terms of teaching, in terms of engagement activities, which is, if you look at it objectively, legal history. And the issue often is that we don't put that label on it personally, or we don't put that label on it collectively, because legal history does seem to have a certain sort of image problem in that people feel that, I can't possibly call myself a legal historian because I haven't spent 5 years studying the yearbooks or whatever it happens to be. And what I argue in subversive legal history is that if you're looking at anything through the lens of both law and history, you're a legal historian. And we need to recognise and value the complementary nature of different forms of legal history. And as we've heard in other presentations today, a general distinction, a very crude distinction, is often drawn between two different types of legal history. The doctrinal legal history was sometimes called the old legal history, sometimes called the internal legal history. I once called it the textual legal history, but it's basically the study of how legal ideas have developed over time. And that's the sort of the stereotypical version of legal history. And then there's the new, the external, the contextual, the socio-legal, the interdisciplinary form of legal history. And that's the way in which history is often used by socio-legal scholars, and often they don't see themselves as contributing to legal history as a discipline. I'm simplifying, I'm caricaturing like mad here, but generally speaking, there is this distinction between the doctrinal and the interdisciplinary. And in the book, I argue that both are needed, and that the way in which we can emphasize this is by changing our labels. And I took inspiration, as you take inspiration all the time in legal history, from the great Sir John Baker. And one of his throwaway comments in an article, a book chapter published in 1977, where he said, law flits uncomfortably between intellectual and social history. And from that brilliant observation, I've developed the argument that the two different forms of legal history, these two different dominant ideas of legal history, could be called the intellectual form, linked to intellectual history, and the social form, linked to social history. And what I'm saying there is I'm making this distinction not to say these need to be kept separately, definitely not to say that one is superior to the other, definitely not to say that we should do one but not the other. What I'm saying is that these two forms of legal history, like the two forms of history which they derive from, are complementary and both are needed. That's my fundamental point there. So the first principle of subversive legal history is that we need to recognise and develop at least an intellectual history and a social history dimension. We also need to make sure that our history is critical and transformative. And we've heard quite a lot today about critical legal theory. And of course, there's also the rich heritage of the critical legal history tradition. And that's often understood as being part of the new legal history, part of the external legal history, and is often seen as being in opposition to the internal doctrinal stuff. But as I argue in the book, this is misguided, and all legal history should be critical. And we need to go back to some of our key sources on critical legal history to really work out what critical legal history is and why it's inherent, why it's absolutely crucial. So my basic argument, I mean, this slide summarizes the book in a slide, which doesn't mean don't buy the book, but nevertheless, this sort of sums up the main argument. And what I'm arguing is that rather than being archaic, as is often seen to be the case, legal history can and is anarchic. Because if you look at the past, you realise that there were other possibilities. There were possibilities that were taken, there were possibilities that were not taken. You realise nothing is universal. You realise nothing is inevitable. And this really frees up the imagination in terms of legal change. So a historical approach to law underscores how the law and legal institutions are not fixed, but are constructed. The courts don't have to operate in the way they do. They don't have to exist in the way that they do. There was a time when things were done differently. There were other options put forward and neglected, often by voices which were not loud enough at the time. That doesn't mean we shouldn't listen to them now. History underscores that every line drawn in the law and everything the law holds as sacred is arbitrary. And the classic example of that is the distinction between contract and tort, which most law schools, most law curriculum, most textbooks, most lectures police vigorously. A historical approach shows that that line is incredibly arbitrary between the two. And so, similarly, the way in which we define legal areas, what's included, what's excluded, is always a historical choice to fit the demands of a particular age. And so, and this is the crucial point, it can be changed. A historical approach underscores that law is a human construct, shaped by the age, shaped by the biases of the fingers which moulded it and which created it. And it also underscores that the environment in which law students are socialized is a historical construct. The things that we expect them to do, both in terms of content and in terms of skills, are a construct, and we can question that. So by using legal history subversively, what I mean is using history to highlight, question, deconstruct and reconstruct the authored nature of the law, revealing that legal change on a larger scale is possible. And David Sugarman, who might be on the call, I know he was here this morning, the great David Sugarman, summed this up in 1992, where he argued that legal history should take on the mantle of an all-purpose subversive, illuminating the connections between legal, socio-economic and political change, thereby enlarging and supplementing the study of law. And there you have it. There you have it in a nutshell. If legal history is doing this thing of being subversive, rather than being something that's the margins of what law schools do, it needs to be, it deserves to be, it has to be at the centre in terms of really questioning what's going on and making sure that we're not simply training students to think like lawyers. We're also training them to question like citizens. So what do I mean? What is meant by critical legal history? Well, here it's important to go back to, and the book relies heavily upon the work of Robert Gordon, the American legal historian. And I really love this quote of what critical history is, because I think this sums it up much better than I possibly could. And what he's saying in this quote is that critical history is any approach to the past that produces disturbances in the field, that inverts or scrambles familiar narratives of stasis, recovery or progress. Anything that advances rival perspectives for survey and developments, or that posits alternative trajectories that might have produced a very different present. In short, any approach that unsettles the familiar strategies that we use to tame the past in order to normalize the present. And again, this hits the nail on the head. As lawyers, we use history to stabilize the present. That's what we're doing when we're going through that case law on the meaning of intention, or whatever it happens to be. But history should actually be used to subvert, to challenge the present. And we can do that by shifting the lens as well, and by not just looking at the orthodox history, but by looking at rival perspectives, different perspectives, and by creating these disturbances in the field. And, you know, quite a lot of what we've heard today would fall under this heading, really. And sticking with Gordon, but moving to his other seminal piece on critical legal histories, and this is reprinted, as is much of his work, in his book Taming the Past, which is a must-read. But what's important here, I think, is that he's outlining what he's attempting to do with this critical approach to legal history. And he's seeking, and I'm going to sort of start this quote halfway through, trying to tease out and make explicit a set of background assumptions, here called evolutionary functionalism, about the course of Western history, but American legal scholars tended to take for granted and to challenge those assumptions. So what he's saying here is that a historical approach, a critical historical approach, a subversive legal historical approach is needed to correct, to highlight and then correct the assumptions which are otherwise there as a result of that dominant form of history being everywhere but not being done critically. And he sums this up as the idea of evolutionary functionalism. Now, for Gordon, evolutionary functionalism underpins the way in which we think and talk about law to such an extent that we don't even realise it's doing it. It's that endemic. And what, in terms of what this means, it does largely what it says on the tin. It's basically a progress narrative in terms of evolution, the idea that the law gets better and better and better over time by itself, it cleanses itself over time. And how many times is that the story we're telling when we're telling students a case law over time of, oh, it was this problem, then it got better, then it got better, then it got better. It's still not perfect, but oh, look, it's much better now than it was over there. And also the idea of functionalism, the idea that at its heart, the legal system works. At its heart, the legal system has equilibrium. And although there may be slight tremors, to change the metaphor, they're exceptional. And most of the time, it works. Now, a critical approach questions that and highlights that. And highlights this evolutionary functionalism, which underpins the way in which we think about law. And legal history is vital as the corrective to this underpinning, which is endemic in law schools. And in this quote from Tame in the Past, Gordon goes through some of these narratives of evolutionary functionalism, which are so dominant that we accept them without thinking. The extension of the market, the breakdown of traditional communities, the shift from ascribed to achieved status, the triumph of the middle class, industrialization, the rise of the administrative state, etc., etc., etc. Now, in the book Subversive Legal History, what I'm trying to do in part, and it's not, it's part of the book rather than the main argument. You've got to get a couple of chapters in to see this stuff. Is that I'm trying to work out, well, if evolutionary functionalism is the wrong, or is the inaccurate underpinning values, what actually are the underpinning values? And I think, and this is just a sort of an initial thought, really, that we've used the wrong scientific idea. And rather than evolution, law is actually, and society and the universe and life is actually shaped by entropy. Now, entropy is the idea of gradual decline into disorder. It's the idea that things get more and more complicated, more and more disorderly, and more and more fragmented as time goes by. And I think if you put this together with complexity theory, which basically, to summarize a huge literature in 10 seconds, complexity theory basically shows that that this increasing mess, this increasing detail, this increasing, well, complexity, the use of a better synonym, is normal. And that what happens over time is that complex systems emerge. And complex systems emerge where there is what is known as emergence, and the idea being that a complex system has emergence where it becomes more than the sum of its parts. So the legal system has become a complex system. There are complex systems within the legal system which have taken on a life of its own, have given the impression of being autonomous, and therefore of being, to a certain extent, in certain ways, unquestionable. And the thing which I think makes this compelling to me is that complex systems hide their chaos behind an image of stability. And that's what law does. That's what particular areas of law do. We call this thing called criminal law. We have this thing called family law. We have this thing called tort law. And all those books on the shelf of, new sort of dozens of textbooks, all with similar titles, all with similar content pages, are all presenting images of stability. Yes, there's going to be certain aspects of each topic on each page where things are unclear, but these are presented as exceptions to the overall norm, to the overall to the overall expectation. And the role of a legal scholar, and often the role of the student, is to further that stability by trying to present the law in an ordered way. So, if you've got a problem question on the law of murder for a criminal law student, for instance, part and parcel of their role is to try and put together the jigsaw of the law on murder in a way that looks rational, in a way that looks ordered, in a way that looks, dare I say, natural, and then apply it to a given problem scenario. And so we're all becoming implicit in this facade of stability. And the textbook tradition, which we've heard quite a bit about today, really does play a role in that, in terms of presenting this is what criminal law is. There is this thing called criminal law. There are these general principles of criminal law. This is what this thing called tort law is. Oh, look, here's some general principles of tort law, etc., etc., etc. And this might be due in part to our sort of unwritten constitution. It might be due in part to the absence of civil codes, absence of criminal codes, etc. But the textbook tradition has played a really important role in terms of English law, in terms of articulating particularly general principles, and also how the jigsaw all comes together. And in so doing that, we've been, I've written textbooks, we've been furthering that image of stability. Whereas a historical approach, a subversive historical approach, which looks at different ways in which things were done, different ideas, different paths not taken, different perspectives, different voices which were not listened to, challenges that. And it shows how authored the law is. It shows how much of a construct it is. It shows how imbued with values and imbued with bias it is. But ultimately, it also underscores how challengeable it is. The great lesson of Toby Milsom, probably one of the leading, if not the leading, legal historians of the 20th century, was the way in which the law develops was getting today's client out of today's difficulty. And that pragmatic lesson, that actually a lot of the things we hold as being sacred, as being natural, as being inevitable, were actually pragmatic, were actually piecemeal, were actually accidental, is a fundamental lesson that legal history can teach. And the whole book on subversive legal history comes from 10 years now of experience of teaching legal history, and before that, having studied it. And when I studied legal history 20 years ago, it was the topic which made my law degree make sense. Because suddenly I could appreciate that all the things which looked firm and looked as if they were natural and universal were constructs, were choices, and were historically contingent. And so I think our role as legal scholars, our role as students, is to uncover the chaotic and unpredictable behaviour of law that is hidden and is to be subversive. And this, I think, has important implications in terms of what we expect and what students can do. It's been pointed out by a number of people at conferences and in terms of book reviews now, that subversive legal history borrows quite heavily upon critical legal history, and absolutely, I don't deny that for a second. And the main reason why it's not just called critical legal history is, well, there's two reasons. One is that I think that term critical is often overused these days in terms of anything that's ever so slightly analytical, we call critical. But also the second reason is that it's linked to that literature, that movement, and ironically, for a legal historian, I'm keen not to be sort of held back by the past to develop those ideas, but to move it forward. And, you know, it may well be that the word subversive is not the right word. It might well be that the word critical is the right word. That's very much for others to say. But I think one of the things I've tried to do in the book, and I'm trying to do through teaching, is to avoid one of the major traps that comes often with critical legal approaches. And a trap that comes with critical legal approaches, there's two. One is that it's seen as being something that's at the margins and has to be at the margins in order to criticise the main thing. But also there's the problem with it that it tends to be by its very nature critical, and therefore quite negative, quite pessimistic, quite nihilistic. And although obviously we are limited by structural matters, we're limited by environmental matters, etc., etc., etc. I think that using legal history subversively can be a positive, optimistic thing, because the key point is that once you really grasp that law is authored and that everything is a construct and everything could be different, then you also grasp that change on a larger scale is possible. And so I've kind of developed the spirit of subversive legal history into a new textbook for students, an Introduction to Law book, which is out in March. And what I've really tried to do there is to do a book which looks on its surface as being quite conventional in terms of the topics it's studying, but actually underneath that surface takes a subversive approach and manifests the ideas in the subversive legal history book, but also is optimistic, because I think if you're writing and trying to engage that particular audience, you have a responsibility to do that, not to sugarcoat, but at the same time, I think it's important to not be entirely nihilistic. So a subversive approach to legal history puts legal history at the real beating heart of what law schools do. And it's the means by which the orthodox accounts of law are highlighted, questioned, deconstructed and reconstructed, showing that they're authored, showing that everything is not fixed but is constructed, that everything the law holds as sacred is arbitrary, and that includes the environment in which law students are socialized. So, in summary, subversive legal history is designed as the answer to two problems: the problem of the perceived narrowness of legal education and the problem of legal history not being flourishing. So in a way, it answers both of those queries, both those concerns raised by Maitland. But also, as I've been saying, on one level, it's not particularly original. Indeed, if we go back to 1886, and again to Maitland, and to a letter he wrote to Dicey, we see the words on the screen which basically sum up what I've been whittering on about the last 47 minutes. According to Maitland, the only direct utility of legal history lies in the lesson that each generation has an enormous power of shaping its own law. I am sure that it would free them from superstitions and teach them that they're free hands. And that underscores for me why legal history needs to be at the beating heart of what law schools do. It doesn't stabilise the law, as it often is seen to do, but it subverts it. Thank you very much indeed.